I guess I would like to say briefly to the families, considering your immeasurable grief, it's completely understandable to hate everything associated with these proceedings. I spent both trials looking out at all the family members, and I wondered to myself, I was looking straight on at Mr. St. Juliana whether or not he'll ever smile again, and that's very difficult. I'm very aware of my job in the situation, very aware of my job, to not be swayed by public opinion, by media, by any of those different things. I can't and will not pretend to understand the pain the families are experiencing, but I did sit through these trials with you. I saw what you saw, I heard what you heard, so I can and will offer my deepest and most sincere condolences for your unfathomable losses. It's as I just said, it's not my role, it's not the role of the court system to make an example of the defendants. However, it is a goal of sentencing to act as a deterrent. These charges are not jury edicts about gun ownership or keeping a gun in a private home. All of the jurors in both trials agreed that they understood that. Parenting is a complex job. Parenting practices around the world share the goals of ensuring health and safety, preparation for life as a productive adult, and transmission of cultural values. Parents are not expected to be psychic. But these convictions are not about poor parenting. These convictions confirm repeated acts or lack of acts that could have halted an oncoming runaway train. About repeatedly ignoring things that would make a reasonable person feel the hair on the back of their neck stand up. Opportunity knocked over and over again, louder and louder, and was ignored. No one answered, and these two people should have and sure didn't. Mr. Crumley, it's clear to this court that because of you, there was unfettered access to a gun or guns, as well as ammunition in your home. You characterized yourself as a martyr and threatened the well-being of the prosecutor. Mrs. Crumley, you glorified the use and possession of these weapons. Your attitude toward your son and his behaviors was dispassionate and apathetic. Your response to school staff after a 12-minute meeting was, "Are we done here?" During your trial, you announced that you wouldn't do anything different. I understand that that might have been misinterpreted, but it did cut the victims deep. Because of both of your actions and inaction, among many, many other things, the world is missing out on a top college university will miss out on Tate's star quality football skills. I met Raina, who's wise beyond her years, and she's told us that among many, many other things, community will be denied Hannah's kindness, creativity, and sense of humor. Among many, many other things the world will miss is Madison's kind and loving soul and the light that reflected her beauty both inside and out. Although a hero in death because of his organ donations that helped so many, we will never know where Justin, an excellent student with vast skills and interests, described as a mentor and a leader, would have left his giant imprint. The impact statements given here and the written statements provided to the court describe the cataclysmic impact the deaths of these children have had on their children. With regard to each defendant, this court has spent night and day thinking about this case, as you can imagine. I've prayed about this case, I've thought about this case, and I've considered the possibility for rehabilitation, the need to protect society, the penalty appropriate to the conduct and goal of deterring others from similar conduct. I have reviewed the pre-sentence investigation reports. I am, of course, sadly familiar with the facts and circumstances of these cases, as well as those surrounding each defendant. The advisory sentencing guidelines in this matter do not capture the catastrophic impact of the acts or inaction in these matters. The guidelines do not take into account the complete lack of insight both defendants have for their behavior to this very day. The guidelines do not account for the severity of the circumstances in this matter. The guidelines ignore the survivors, including shooting victims Phoebe Arthur, Elijah Mueller, Riley Franz, Kylie Osage, John Asciutto, Molly Darnell, and Aiden Watson. They were deeply wounded, both physically and emotionally. In addition to the 7 wounded, each of the defendants' gross negligence has caused unimaginable suffering to hundreds of others as a result of what happened that day. Each act or inaction created a ripple effect. Therefore, an out-of-guidelines sentence is appropriate and proportional. The court uses the useful tool of the legislative guidelines, which embody the principles of proportionality, while also taking into account the nature of the offense and the background of each defendant. I believe that the following sentences would be in the best interest of justice and are reasonable and proportionate to the seriousness of the matter and the circumstances surrounding each defendant. With regard to Jennifer Crumley, it is the sentence of this court, Ms. Crumley, that you serve 10 to 15 years with the Michigan Department of Corrections. You will have credit for 858 days. State costs are $272. There's a crime victims' rights fee of $130. You and your agents may not have any contact with the families of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. I will issue another ruling with regard to contact with your son, the shooter. Excuse me. As to defendant James Crumley, it is the sentence of this court that you serve 10 to 15 years with the Michigan Department of Corrections, that you receive credit for 858 days, that you pay state costs in the matter of $272, that there is a crime victims' rights fee of $130, that you or your agents have no contact with the families of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. Ms. Wheeler, have I left anything out with regard to sentencing? No restitution has been requested by any of the families at this time, correct?
That's correct.
Thank you. I would like to advise both defendants that you are entitled to appellate review of your conviction and sentence, including that the sentence exceeds the guideline range. This is done by filing a claim of appeal by right, or when you are not entitled to file a claim of appeal by right, an application for leave to appeal. If you cannot afford to hire an attorney to represent you on appeal, and you request an attorney may be appointed for you. You may request an attorney by completing the request for appointment of attorney section of the form that will be provided for you, and by returning the form to this court or to the Michigan Assigned Counsel System at the address on the form. If you wish to preserve your automatic right to appeal, the form must be received within 42 days after sentencing. If you do not submit the form within 42 days from today, you may still file an application for leave to appeal if the form is received within 6 months after sentencing. Do each of the defendants acknowledge receipt of their appellate rights?
James acknowledges receipt, Your Honor. He's completing the form as we speak.
Your Honor, my client is as well. Would the court like the forms here, or would you prefer us to?
It doesn't matter either way.
Okay.
Either way.
Thank you.
Thank you. I'm going to ask that everyone remain seated while the defendants are taken out of the courtroom. I think they're going to finish their appellate rights.
They are going to. Mr. Crumley is going to finish his form,
All
Your
right.
Honor.
We'll wait for that.
Thank you, Your Honor.
I would just ask that no one stand up. It makes the deputies nervous.
You're watching a Michigan courtroom where the judge has just sentenced the parents of a Michigan school shooter to 10 to 15 years in prison for their roles in their son's attack. The judge said she thought and prayed about this case and reviewed the guidelines, but those guidelines, she says, did not take into account the deep emotional wounds and suffering that stemmed from the attack, nor the effect the attack had on the wounded and the ripple effects beyond that. I want to bring back ABC's Trevor Ault outside that court in Michigan, along with ABC News legal contributor Shauna Lloyd for more. Trevor, I want to start with just the historic nature of this case. These are the first parents ever convicted in a school shooting committed by their son, and now we have their sentences going beyond the guidelines, the judge saying 10 to 15 years each. What do you think?
Well, it's absolutely not a slap on the wrist. That is absolutely my first reaction, Diane. This is a very serious sentence for what the judge clearly believes were very serious crimes that impacted not just those 4 students who were killed, but as she stressed, all of those 4 students' families, all of the many wounded in the school, and the thousands more in the community beyond it. So this is clearly, in the judge's eyes, not just a historic conviction, but also a correct conviction. And we heard her detail why she felt these parents were so irresponsible in buying that weapon and celebrating that they had purchased a weapon for their son as he was showing all these red flags for his mental health, failing to secure the gun. She accused Jennifer Crumbley of being apathetic to her son and her son's mental health, and failing to take him home from school that very morning here. So not only does the judge feel that the sentence is correct, but also she agreed with the prosecution's recommendation. They had asked for 10 to 15 years, and they got 10 to 15 years. And just to give some clarity here in terms of the guidelines that the judge is referring to. So involuntary manslaughter in the state of Michigan carries a maximum penalty of 15 years in prison. But there are general guidelines as to what the sentence might be. Obviously, not all cases are going to be the most extreme of 15 years. Some will warrant a penalty far less than that. Generally, the recommendation is a maximum of about 7 years. Now, in those cases where it seems to be a bit more extreme, the judge has that authority to go much further. And she said this one seems very clearly to be an extreme case to exceed those guidelines. So now, with a sentence of 10 to 15 years, that means at a minimum now, James and Jennifer Crumbley are going to be looking at being in prison until late 2031, 10 years after their son committed this heinous act. They expressed their condolences to the family for the families of the students that their son killed. But now they are the first American parents who are also going to pay for their role, not only for being necessarily bad parents, as the judge had said, not for being bad gun owners, but for being criminally responsible for the deaths of these 4 students, Diane.
And Shauna, when the judge says 10 to 15 years, what does that mean? What now determines whether it's 10 or 15 or somewhere in between?
What's going to happen is they're going to go before the parole board. They will set that, and then they will also receive, there is times for good behavior and other things that can also keep that closer to the 10 as opposed to the 15.
And Shauna, the judge opened almost immediately when she went on to why she found them culpable and why she found that they earned the sentence. And she said opportunity knocked louder and louder and was ignored. What did you make of that moment?
You know, I think this was the judge really looking at each instance that she felt that they could have made a different choice and that they ignored it. And to her, that showed that the totality of this really could have been stopped by the parent and that it was not. And therefore, she felt that that warranted the sentence because it wasn't one particular incident. It was a series of incidents that led up to this that they could have made changes and they chose not to.
Trevor, she also brought up that meeting that the Crumbleys had in the school that day, that they were called in by a counselor because of this disturbing drawing that their son had made. And they had this 15-minute meeting, and she quoted Jennifer Crumbley as saying, "Are we done here?" after those, 15 minutes or whatever it was for that meeting. How much did that meeting, just hours before the shooting, impact not only their cases where they both got convicted, but now their sentencing as well?
I mean, I think it was critical, Diane, because it speaks to beyond the fact that they had purchased the weapon for their son or they had not necessarily been responsive to his mental health. I mean, this was about as close as you could get to a cry for help when you have your son called in for an emergency meeting, to the point that we know Jennifer Crumbley texted her husband James, all caps, emergency, about this drawing in which he had drawn the gun that they bought him and a person who had been shot and was bleeding, and wrote out, along with the thoughts won't stop and blood everywhere, he wrote out, "Help me." And according to the school officials who testified, while the parents showed up, this was a very brief meeting. They did not ask very many questions. They seemed a little apathetic, according to those school officials, and then concluding it, yes, with not only are we not taking our son home, because Jennifer Crumbley said she needed to get back to work, and so did James, even though Jennifer's boss said she did not need to get back to work, and James worked as a DoorDash delivery driver, so he set his own hours and could have taken his son with him. But Jennifer Crumbley saying, "Are we done here?" speaks to that apathy that the judge referred to, where it seemed that these parents, not only were they perhaps oblivious to their son's red flags, but they also didn't even necessarily care about them. And for that to happen less than 2 hours before this school shooting happened, it not only paints to the fact that they were ignoring all of those signs, but it was top of mind to the point that when they learned a shooting had happened, those 2 hours later, Jennifer texted her son, "Ethan, don't do it." And James Crumbley, shortly after, raced home to check to see if the weapon was still there. So certainly there was enough to put it in their mind that their son was capable of this when they learned that a shooting had happened. Whether or not they're ever going to admit that they realized this was a possibility, I don't know that we'll ever see the day. Perhaps we will see an appeal. But clearly this judge was swayed by the arguments of the prosecution that these parents were grossly negligent, not just once, but over and over again, leading to this shooting.
Shauna, that said, we did hear during their trials and today during Jennifer Crumbley's statement that the school asked them if they were going to take their son home, but didn't tell them they had to take their son home. And Jennifer Crumbley saying the school said he was not a threat at that time. So could this all open the door for more charges or other impacts against school officials here?
You know, I think what we're going to see, Diane, is really going to be civil cases against the school. Their lack of preparation, training, or addressing the situation at the time. I think we will see a lot of civil suits come out of this against the school. I don't see it likely rising to a criminal level, but there will absolutely be lawsuits in the civil arena from the parents against the schools and the actions that they took in releasing him back to the students, potentially not having him searched at the time. Those things are going to definitely warrant that type of litigation.
And Shauna, we saw two first-of-their-kind cases, now a first-of-its-kind sentencing. What kind of a precedent does this set? 10 to 15 years for each of them.
I mean, this sentencing really set a standard, and this judge was very clear about what she saw and why it warranted this level of a sentence. Now, let's remember, Michigan does have a very specific statute that gives parents a duty to require them to not have their children injure others. Not every state has this statute, so I don't know that we're going to see wide sweeping charges in these school shootings. However, what we might see is additional legislation to put this on the books. This may be something that legislators want to look at to make sure that other parents can be held accountable when it is a crime and that it's this egregious.
So, Trevor, what are the next steps?
Well, the next step is that James and Jennifer Crumbley are going to be heading to a state facility. It's possible that they will then play out the appeals process. We'll have to see what their defense attorneys decide they want to do, whether appealing the conviction or appealing the sentence. You also have their son, who's facing life in prison without the possibility of parole, potentially appealing his sentence as well. So they may use the fact that his parents have now been convicted for being grossly negligent as reason for him to argue that he did not necessarily have he didn't get the help that he needed, or that he had, if his parents were criminally irresponsible, then perhaps that should be considered with his own sentencing for his own crimes. And then playing out over all of this is those civil lawsuits against the school. You heard from some of the parents in their impact statements today talking about how they want even more accountability. They want investigations from the government, but specifically already in motion are multiple lawsuits, some of them for millions of dollars against the school and the school officials who testified in James and Jennifer Crumbley's trial, in which they admitted under oath that they did not consider the shooter to be a threat to other students just hours before he killed those 4 students. That's going to be the next step in this case. And the parents of these victims, while they are very satisfied to have these convictions, and the prosecution is very satisfied to have these convictions, they have said from the beginning they are not done here. They want the school to be held accountable too.